Greetings and welcome back to Categorical Imperatives. As always, I am Lockean Liberal. Thank you for joining me. This, of course, as I'm sure most of you know, is the podcast where we use legal and moral philosophy to discuss current events on topics surrounding politics and culture. Today's video is going to be a part two, picking up where we left off last time with an article that we were looking at from the Washington Post that was talking about uh, gun control. Specifically, the article was about what the Second Amendment really meant to the founders. Now, if you haven't seen part one, it's definitely really important that you go back and watch that to get caught up on what we're talking about here. So I will put a link to part one down in the description for you to go and check out. But just to kind of refresh your memory here, what we have been doing is actually going through this article together and using it as kind of a learning tool in our pursuit to understand how it is that the meaning of the Second Amendment has managed to become so obfuscated in our society today, and why we have such vastly different opinions, depending on who you ask, of what exactly the Second Amendment really means. And what we have been doing is we have been going through, and I have been showing how this difference comes, and by difference I mean difference essentially between the view that the Second Amendment is a collective right of state militias versus the view that the Second Amendment is an individual right to keep and bear arms for self-defense, not necessarily connected with militia service. And as you will recall, the reason that we have these two very different conclusions is because they are being reached using two very different modes of interpretation. So I just want to go over those with you again real quick. They are, of course, original intent and original meaning. And so I wanted to just remind you here to define these terms for you again. Original intent maintains that in interpreting a text, a court should determine what the authors of the text were trying to achieve and to give effect to what they intended the statute to accomplish, the actual text of the legislation, notwithstanding, as in purposivism, tools such as legislative history are often used. And otherwise, original meaning, which is also commonly known as original public meaning, the same thing. Original meaning is defined as how a reasonably intelligent, involved member of the public would have interpreted a provision at the time that it was drafted. It relies on primary evidence of original meaning based on how words were used both in common discourse as well as official definitions we can find from contemporaneous sources of the time, from the time period it was drafted, by which I mean sources such as dictionaries, statutes, legal treatises, things like that. So now that we're kind of caught up on where we are, let's get going with the next point we have in the article. So, point two of the article. The amendment's primary justification was to prevent the United States from needing a standing army. Preventing the United States from starting a professional army, in fact, was the single most important goal of the Second Amendment. It's hard to recapture this fear today, but during the 18th century, few boogeymen were as scary as a standing army, an army made up of professional, full time soldiers. By the logic of the 18th century, any society with a professional army could never be truly free. The men in charge of that army could order to attack the citizens themselves who, unarmed and unorganized, would be unable to fight back. This was why a well regulated militia was necessary to the security of a free state. To be secure, a society needs to be able to defend itself. To be free, it could not exist merely at the whim of a standing army and its generals. The only way to be both free and secure was for citizens to be armed, organized, and ready to defend their society. The choice was a stark one: a standing army or a free nation. Now, if you'll kind of remember where we left off last time, uh, his first point where he was talking about they saw the militia as being the founder saw the militia as being important, and because the militia was important, he said the Second Amendment was created to divide up the role of the militia between the state and federal government. And if you'll remember, we went through very thoroughly, we went through what were called the congressional war powers that are found in Article 1, Section 8 of the Constitution. We showed you how the militia clauses in the Constitution already perfectly clarified that issue with the Constitution that was drafted and then ratified, which was several years before the Bill of Rights was then drafted and ultimately ratified. Uh, so that was a non-issue. That was already a non-issue at the time of the writing of the Second Amendment. So now picking up with this point, in a way, it almost makes even less sense than the last one because just like his assertions about the militia uh, being already clarified in the Constitution, as I said, as part of the congressional war powers years before the Second Amendment was ever a thing. His claim here about a standing army is directly contradicted by Article 1, Section 8, Clause 12. This is, again, part of the congressional war powers. This is what is commonly known as the Army Clause. And this is what specifically grants Congress the power to form a standing army. And it says, the Congress shall have the power to raise and support armies, but no appropriation of money to that use shall be for a term of longer than 2 years. So, the founders, there is some truth in the idea that the founders did see a standing army as potentially dangerous. And in fact, there were certainly some founders who did not want a standing army at all. There is some truth to that. However, the general consensus that you would find is that most generally saw standing armies in times of peace as the real danger. But regardless of that, what we see here in the Army Clause is that the Constitution clearly provides for the ability to create a standing army when the Congress deems it necessary. Now, there are countless examples that demonstrate the common understanding of the congressional war powers, that it created the ability to form a standing army, but that the right of all citizens to keep and carry private arms created a general militia which would be insurmountable to a standing army, and that this would be a more insurmountable force the general militia would than any standing army that a government could raise. And if we want to get a good understanding of this, there's a couple good sources to turn to. So we will be turning to James Madison and his writings in Federalist Number 46, as well as a portion of an article that was written by Noah Webster, known as Citizens of America. Both of these articles were written during that period between September of 1787, when the new Constitution had been proposed by the Philadelphia Convention, uh, but before June of 1788, when the requisite 9 states ratified the Constitution and made it the new law of the land. So, uh, both of these two articles that we're about to look at will make the case that any attempt by the federal government to turn the standing army against the people cannot happen as long as the militia exists, owing its loyalties to the state before the federal government, and as long as the people are guaranteed in their right to keep and bear private arms. So let's look at exactly what it was that Madison and Webster actually had to say about this. James Madison starts in Federalist 46. Extravagant as the supposition is, let it however be made, let a regular army fully equal to the resources of the country be formed, and let it be entirely at the devotion of the federal government. Still, it would not be going too far to say that the state governments, with the people on their side, would be able to repel the danger. The highest number to which According to the best computation, a standing army can be carried in any country does not exceed 1/100th part of the whole number of souls or 1/25th part of the number able to bear arms. This proportion would not yield in the United States an army of more than 25 or 30,000 men. To these would be opposed a militia amounting to nearly 500,000 citizens with arms in hands officered by men chosen from among them. And he goes on, uh, fighting for their common liberties, uh, and united and conducted by governments possessing their affection and their confidence. It may well be doubted whether a militia thus circumstanced could ever be conquered by such a proportion of regular troops. Those who are best acquainted with the last successful resistance of this country against the British arms will be most inclined to deny the possibility of it. Besides the advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached forms a barrier against the enterprises of ambition more insurmountable than any which a simple government of any form can admit of. Notwithstanding the military establishments in the several kingdoms of Europe, which are carried as far as the public resources will bear, and where the government are still afraid to trust the people with arms. And moving on to Noah Webster, he says, another source of power in government is a military force, but this, to be efficient, must be superior to any force that exists among the people or which they can command, for otherwise this force would be annihilated on its first exercise of acts of oppression. Before a standing army can rule, the people must be disarmed, as they are in almost every kingdom of Europe. The supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed and constitute a force superior to any band of regular troops that can be, on any pretense, raised by the United States. So, when we consider these historical sources versus what the author says we should find in the historical sources, I think there is a clear contrast in what we find. Uh, if you remember earlier in the last video, I was talking about, among other things, as far as framing devices, something that I called anachronistic legal interpretation. And so, if you remember, if we are to assume as true the sort of the anachronistic interpretation that we get from the text of the article from the Washington Post that we just read from, it might be suggested that the right to have arms is dependent on a militia being necessary to the security of a free state. But despite what the amendment declares, the militia is obsolete because today a standing army allegedly protects a free state. Ergo, no right to arms exists. But this would mean rephrasing the entire amendment as a conditional hypothetical syllogism. And I've mocked up such hypothetical syllogism. This is what I call my anachronistic Second Amendment. If we were to rephrase the amendment as the author of the article would have us perceive it, it would really uh, be right to say if a well regulated militia is necessary to the security of a free state, then the right of the people to keep and bear arms shall not be infringed. So, if a well regulated militia is necessary to the security of a free state, which is statement P, then the right of the people to keep and bear arms shall not be infringed, statement Q. That is to say, P implies Q. If one then asserts P as a second premise, then the conclusion Q follows. And this is something that logicians will speak of as a syllogism that is considered valid by reason of modus ponens. Now, modus ponens allows one to eliminate a conditional statement from a logical proof or argument being the antecedent, and therefore to not carry these antecedents forward into an ever lengthening string of symbols. And it is for this reason that modus ponens is sometimes referred to by logicians as the rule of detachment or the law of detachment. All right. So, moving on with his article, we now get to, oh, excuse me. Uh, there we go. Sorry about that. We now get to point three. The authors of the Bill of Rights were not concerned with an individual or personal right to bear arms. Before the landmark 2008 Supreme Court case, District of Columbia v. Heller, courts had ruled that the right of the individual citizens to bear arms existed only within the context of participation in the militia. In Heller, the Supreme Court overturned that precedent, delivering gun rights advocates their biggest legal victory. This was not, however, a return to an original understanding of the Second Amendment, as Justice Antonin Scalia claimed for the majority. It's not that the founding fathers were against the idea of an individual right to bear arms, it's just not an issue that concerned them. Again, the militia was all important. The men writing the Bill of Rights wanted every citizen to be in the militia, and they wanted everyone in the militia to be armed. If someone was prohibited from participation in the militia, the leader of the founders' generation would not have wanted that person to have access to weapons. In fact, the 18th century regulations that required citizens to participate in the militia also prohibited blacks and Indians from participating as arms bearing members. So, I'm sure already there are many of you out there who are very familiar with this case that he talks about, the 2008 Supreme Court case of TC versus Heller. This is, of course, the case where noted fascist Antonin Scalia overturned 200 years of Supreme Court precedent that has consistently ruled over and over again that the Second Amendment is a collective right of a state to have militias. That is, of course, until this one unelected Supreme Court justice penned the greatest lie that the NRA ever corruptly bribed into existence. And on the other hand, for those of us who have actually bothered to read the legal brief, including the oral arguments, all relevant amicus briefs that were filed with the courts, the full compendium of past case law that had any bearing on the underlying constitutional law issues that were addressed by the Heller Court, and not only the majority opinion that was written by Justice Antonin Scalia, but also important is the dissenting minority opinion that was penned by Justice Stevens. Uh, and that essentially the Heller case uh, upheld both the Constitution and past case law when it said that the Second Amendment protects an individual right not necessarily dependent on militia service. Now, at some point very soon, I do intend to do a video about the right to keep and bear arms beyond this issue of the Founder's Second Amendment. So we would be discussing its role in the 14th Amendment, as well as both the 19th and 20th century civil rights movements and all relevant case law that relates to the right to bear arms in any sense, from Dred Scott to Cruikshank to Miller, Heller, and McDonald. Um, if that's something that people would like, if that you would be keen to see, let me know in the comments, and I would be happy to make that a priority. I don't want to get too stuck on Second Amendment and gun control stuff here, but yeah, let me know if that's something you would be interested in, and I can kind of bump that up on my list of priorities. But at the moment, I want to try and do what the author of this article on the Founder's Second Amendment doesn't seem to be able to do, and that is restrain my argument to the Founder's Second Amendment. So, really, again, what we have here in point three is we find him once again assuming anachronistic intent. Uh, this article is supposed to be about, as I said, the founder's Second Amendment. His points about banning people from bearing arms on the premise of their race is not something that I have found anywhere in the Second Amendment, and I assure you I have looked. Now, the 18th century uh, federal regulations that he is talking about are the Militia Acts of 1792. We did touch on these briefly last time, but it's important to keep in mind that the Militia Acts of 1792, with very few exceptions, are not the Second Amendment. So, i- furthermore, even that regulation, the Militia Acts of 1792, does not do what he claims it does. If you remember, the Militia Acts of 1792 defined in law both the select and the general militia. Now, it is true that in the select militia, membership was limited to freeborn males between the ages of 17 and 45. Now, in 1792, that usually probably meant white. But to say that one branch of the militia was kind of sort of limited to white men between the ages of 17 and 45 is not at all the same thing as saying what he has claimed that blacks and Indians were barred from owning weapons. These aren't even close. The fact is, they aren't even really barred from participation in the militia. Uh, if you want to go with that loose definition, that freeborn male means only white male, which I think is a little unfair. But even if we do go with that, let's say uh, every the that again, we're just talking about the select militia at this point. The unorganized militia, the unorganized militia was created right in the statute without any distinction of qualification. Essentially, the general militia says that every adult with arms willing to use them in defense of themselves, their community, or their country could rightfully be said to make up the general militia. Now, if our early legislators had wanted to exclude all those outside the militia from bearing arms, it would have been very easy to write that into the law, but they didn't. So even the laws relating to the militias do not do what he claims they do. And again, I, I hate to keep harping on this, but since he seems to keep forgetting, I want to remind people that we're supposed to be talking about the Second Amendment here. The Militia Acts is a statute. Now, if we go back to what my real key point was that I was drilling home in the last video and in most other videos, the Militia Act is a statute that makes it the law that governs us. The Constitution is the law that governs those who govern us. These are, d- um, in a sense, entirely unrelated when you look at it from that perspective. Simply put, one of these things is not like the other. Now, let's take some time here and take a closer look at what the founders did have to say about the right to bear arms directly. Uh, is it true that an individual right to bear arms was something that they never concerned themselves with, as the author claims? Uh, I think a good place to start with answering that question would be with the founder, who is known as Tench Cox. I suppose just as a little aside here, I know Tench Cox is largely unknown to most people, and since I'll be referencing him here several times, and also since he is, in my opinion, second only to maybe Roger Sherman on a list of founders that no one knows and everyone should. Uh, I want to give you just a quick, brief little rundown of who Tench Cox is and why he matters. So, Tench Cox was a Constitutional Convention delegate. He served under Hamilton in Washington's Office of the Treasury and as Washington's Commissioner of the Revenue. During the Jefferson administration, he served with James Madison in the State Department. and was made purveyor of public supplies, which, among other things, put him in charge of procuring all military supplies, a role in which he continued in under the James Madison presidency, as well as serving as both an advisor to and speechwriter for James Madison. Now, during Jefferson's presidency, Cox was largely responsible for helping Jefferson reach what was one of his most important goals, which was to have the size of the standing army that existed and to encourage militia membership. And this is interesting because what we see here is that already by 1800, when Thomas Jefferson takes office, we have a standing army. And what we see here is that Thomas Jefferson, who I think it would be fair to say was one of the most virulent voices in speaking out about the dangers of a standing army. Uh, but even he saw value in maintaining a standing army. He didn't get rid of it, he didn't disband it, he could have. He just wanted it to be smaller than it previously was to keep it in check. It's not that a standing army didn't exist. It's not that they were scared of a standing army. They just wanted to keep it in check. So let's move on to what Tench Cox has to say. The first quote comes from an article he wrote called Remarks on the First Part of the Amendments to the Federal Constitution. This was published in 1789. And he says, whereas civil rulers, not having their duty to the people before them, may attempt to tyrannize, and as the military forces which must occasionally be raised to defend our country might pervert their power to the injury of their fellow citizens, the people are confirmed by the article in their right to keep and bear our private arms. Next up, this is from an article called Democratic Press that Tench Cox wrote in 1823. And what he says is enshrined in our Constitution is the right to own and use arms, and consequently of self defense and of the public militia power. While the English game laws were used to disarm the populace, here firearms are the second and better right hand of every freeman. Having arms is sometimes a duty, but it is ever a right. So prudent, faithful, and provident have our people and Constitution been that we find in their precious bills of rights, schedules of duties, and reasons of powers, and declarations the right to own, keep, and use arms. Provisions preventing and forbidding the legislatures to interfere with and to abrogate that all important right of the citizens. We have another quote here from Cox. This is, as you'll see from the Pennsylvania Gazette, penned in 1788. He says Congress have no power to disarm the people. Their swords and every other terrible implement of the soldier are the birthright of an American. The unlimited power of the sword is not in the hands of either the federal or state governments, but, where I trust in God it will ever remain, in the hands of the people. And I just want to point out this harkens back to something that I very briefly touched on in the first video, and that was the Federalist argument for why a Bill of Rights was unnecessary. And when it came to something like the right to keep and bear arms specifically, the argument that they made was, y- you don't have to worry about Congress disarming the people because there's absolutely nothing in this Constitution anywhere that could possibly be construed as granting Congress the power to disarm the people. Here we see Tench Cox making that point directly. So, kind of when we take these all together, what we see here are several quotes from a founder over a period of decades talking about our Constitution's protection of an individual right of all citizens to own and carry and use their own private arms, and that the government cannot, under the Constitution, disarm individual citizens. Notice there has not been one mention of the word militia anywhere in here. Moving on, where do we got? We got Alexander Hamilton, Federalist 28. This is fairly straightforward. He says, if the representatives of the people betray their constituents, then there is no recourse left but in the exertion of that original right of self defense, which is paramount to all positive forms of government. So, are we to believe that what Hamilton is telling us is that if the government turns against the people, that the people have the right to serve in a select militia created and armed by the same despotic government that they are arming to defend themselves against? That the government will call forth an army and a militia to turn against themselves when they become corrupt or abusive of power or tyrannical? Eh, yeah, that speaks for itself, really. Moving on, we got Sam Adams, and this, as you can see, was a quote that came during the debates and proceedings for the Constitutional Ratification Convention. This was as they were ratifying it, and he was making official suggestions as part of the ratification about what a Bill of Rights should include. And what he says is that the said Constitution shall never be construed to authorize Congress to infringe the just liberty of the press or the rights of conscience or to prevent the people of the United States who are peaceable citizens from keeping their own arms. So this could not be a more clear endorsement by one of the most important founders, where he states in absolutely clear terms that the citizens have an individual right to private arms, and he puts this individual right on the same level of protection that we consider an individual right when it comes to our rights of a free press, our right to practice our own religion, things of this nature. Uh, Rights of the people that I don't think anyone would argue are collective rights. So moving on, another uh, underappreciated founder is a gentleman named Saint George Tucker. Now, Tucker was a Revolutionary War vet. He was appointed a district court judge by James Madison, and really, most importantly, both in general and to our conversation here, I would say, uh, he wrote an American edition of Blackstone's commentaries on the English common law, in which he essentially annotated Blackstone with a legal treatise that contrasted and compared English common law with American law, both precedent as well as our Constitution. Now, his commentary on Blackstone is universally considered to be the first great legal treatise on American law. To give you some idea, it was cited by more lawyers arguing before the Supreme Court than any other legal commentator up until 1827. And in fact, uh, Blackstone's reading of, or excuse me, Tucker's reading of Blackstone is itself found mentioned in the rulings for more than over 40 Supreme Court cases. So, this is Tucker's take on the Second Amendment compared to the English common law right to bear arms. The right to keep and bear arms. This may be considered the true palladium of liberty. The right of self defense is the first law of nature. In most governments, it has been the study of rulers to confine the rights within the narrowest limits possible, where standing armies are kept up, and where the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited. Liberty, if not already annihilated, is on the brink of destruction. In England, the people have been disarmed under any specious pretext of preserving the game. Uh, the people are disarmed under this mask, though calculated for very different purposes. This is was that the third time that one of these quotes has mentioned these English game laws. Uh, I won't uh, go into it too much, but essentially, with the English Bill of Rights of 1689, we find in there a right of Englishmen to keep and bear arms. And the game laws was something dreamt up by Charles II to disarm the people without breaking the English Bill of Rights by using a specious pretext. So it was really basically the uh, Stuart dynasty's uh, equivalent of what today would come in the form of.
Won't somebody please think of the children?
Think of the children. Won't somebody please think of the children?
No, stop. Think of the children.
Think of the children. Won't somebody please think of the children?
All right, so that hopefully gives you some idea of what we are talking about here. Next up, as you see, is a quote by a gentleman named William Sumner. This comes from an article that was written in 1823 or published in 1823 that talks about the importance of the militia to a free commonwealth. And he says, uh, oh, hang on. Oh, first I should say, this comes from a letter that was written by William Sumner to John Adams. This article or this letter, excuse me, was then later published as the article, "The Importance of a Militia to a Free Commonwealth." And when this article was printed, it was actually included a preface written by John Adams praising Sumner for so perfectly capturing the spirit of our militia and of our right to keep and carry arms that the revolution embodied. And what William Sumner says is the United States would be a target for invasion if its population, like that of Europe, chiefly consisted of unarmed peasantry, and its whole reliance was on its regular army. One pitched battle would decide its fate. But an army of well trained militiamen is not conquered when the army is beaten. Here, every house is a castle, every man a soldier. Arms are in every hand, and it is better that the arms should be kept by the men themselves at their own dwellings rather than a public arsenal. They thus learn to take care of them at least, and as opportunities for hunting and practice shooting offer, they improve as marksmen. Now, this too goes back to something we briefly touched on in the first video, and that was I was trying to explain the meaning of the term well regulated and how differently it's used when you look at it through original public meaning, which is understandable why people today give it, they assign it the meaning that they do, which is something like well regulated means something that is uh, formal and regimented and disciplined, and people, expected to join a militia that was heavily guided and tightly controlled by the government. But if you'll remember, when we went back to the contemporaneous sources and we looked in both just regular dictionaries as well as legal sources, the definition of well regulated is universally taken as to make regular. And so, as I said in the last video, that is to say uh, that it should be a militia of people who have you know, a regular, well functioning understand of their firearms and of how to use them, and something of that nature, essentially. And so, this article here kind of touches on that. He said they thus learn to take care of them at least, and opportunities for hunting and practice shooting offer. They can improve as marksmen. All right, moving on. So, next, as you see here, this was Thomas Jefferson's suggestion of how he thought the right to arms should have been laid out in the Virginia Declaration of Rights that was eventually written by George Mason. However, Thomas Jefferson's proposal was very simple: no free man shall ever be debarred the use of arms. And next up, we have a suggestion that came from Patrick Henry now, and this came up in the Virginia Ratifying Convention for a proposal, but this was about what to add as amendments to be what would eventually become the Bill of Rights. And Patrick Henry's right to bear arms essentially said the great object is that every man be armed. So, I think let's see what some of the states have to say about the right to keep and bear arms in their constitutions. Because keep in mind, all these state governments that were formed at the same time that the federal government was formed, which means that on top of our federal constitution, that these what became states had drafted their own constitutions and their own Bill of Rights. And as a matter of fact, because the Constitution didn't come into effect until 1788, with before having the Articles of Confederation that governed us. Uh, this means that the state constitutions, in many cases, were actually written years before the federal constitution. So I think it would be fair to say that what the state constitutions have to say in the instances that they are written before the drafting of the Constitution and the Bill of Rights, that it stands to reason that the people of these states, uh, this was how they would have likely seen the Second Amendment, or how they likely would have defined it. So, let's see. We have the Vermont Constitution. This was written in 1793, and this is Article 16 of that Constitution, that the people have a right to bear arms for the defense of themselves and the state. So we have a right of the people to bear arms for their personal defense and defense of the state, without any mention anywhere of anything like a collective militia proviso. And we turn to the Pennsylvania Constitution of 1790. This is Article 21, as you can see. Their state constitution reads the right of the citizens to bear arm in defense of themselves and the state shall not be questioned. Uh, so, moving on here, we besides the I think it's probably worth mentioning that those two clauses from the Pennsylvania and Vermont constitutions from 1790 and 1793, respectively, uh, those are the same constitutions they have today. That's not just what their constitutions or Bill of Rights said at some point in the past. It's at some point in the past and still is today. Now, besides state constitution, the author of the article we're going over has specifically said one of the historical resources that he himself is drawing his educated conclusion from are from the formal proposals made by the states during the constitutional ratification conventions, where the states debated suggestions for a federal Bill of Rights that were submitted as a formal proposal, along with the documents of ratification that each state drew up as part of the first federal constitution. So let's get into that source right now and see how well his claims of what they say uh, match up to what we see before us. the Convention of the State of New York suggested that the people have an equal, natural, and unalienable right to keep and bear arms, that a well regulated militia, including the whole body of the people capable of bearing arms, is the proper, natural, safe defense of a free state. This is really a perfect example of how the first clause in the Second Amendment, the prefatory clause, establishes the importance of the general militia, and the second clause then says how we are going to protect it. And that's exactly what this is doing right here as well. Next up, we have the Convention of the State of North Carolina and their ratification document and their suggestion for the Bill of Rights said that the people have a right to keep and bear arms. And continuing to move on from the Convention of the Great State of New Hampshire, their proposal was Congress shall never disarm any citizen unless such as are in or have been a state of rebellion. And uh, with the Pennsylvania ratification document, what they proposed for a federal Bill of Rights included this that the people have a right to bear arms for defense of themselves and their own state or the United States, or for the purpose of killing games, and that no law shall be passed disarming the people or any of them unless for crimes committed. And what do we have next? We have the Convention of the State of Virginia. What they proposed be uh, added to the Bill of Rights was that the people have a right to keep and bear arms, that a well regulated militia composed of the body of the people trained to arms is the natural defense of a free state. Now, again, I want to harken back to something that you uh, may well remember from the last video we did, and that is very early on in the article, the author makes a statement where he says, how does he put this? He says that according to, I believe he said Federalist and Anti Federalist, uh, that they both defined, or excuse me, they both made the claim that a well regulated militia composed of the body of the people uh, is the best defense of a free state. And really, at this point, I think this collective body of evidence uh, of the leading legal mind from the founders' generation, as long as what we see in the state constitutions they penned, as well as the official ratification documents the states submitted for their suggestions of their conception for the particulars for a federal Bill of Rights. Uh, I don't think the author of this article is being intentionally dishonest in suggesting there was no evidence that supports that supports the individual rights Second Amendment. I I think he is so entrenched in anachronistic legal interpretation that anything other than the collective rights view that he has already concluded before considering evidence really essentially psychologically made any other possible outcome or definition uh, just literally inconceivable. Uh, I can't say this for sure. I don't know him personally, but I just for what it's worth, that is really the impression that I get when I read his writings. So this will be the end of part two here, and we will be back for a very short uh, part 3 in a couple days. Uh, that's going to be a very brief video, just a summary, not anything like this here. So until next time, this has been Categorical Imperatives. I have been Lockean Liberal, and we have been talking about the Founder's Second Amendment. Until next time.